Item number 11, there is extreme urgency. This is a matter where a conviction was passed by the learned magistrate, case of 2007. From 2007, the petitioner, he has been on bail. Thereafter, your lordship knows 3 years and below, he would remain on bail if it is confirmed by the appellate court. So the matter went to Sessions Court in appeal in Mayavandar. Sessions Court matter was pending for pretty long. Now in December, the matter has been disposed of, conviction has been upheld. He has been given 1 month's time to prepare revision, bring the order, otherwise the warrant would be issued. So my lord, that 1 month is expiring today. So that is why, my lord, there is some urgency. The matter has to be heard out with the LCR being called for. This
LCR is not with the record.
my lord will admit it, call for the LCR, then it will come. LCR will be with the last appellate court.
Yes. Okay, it should be taken up today.
Madam.
Don't worry. Yes. Item number 1.
Item 1, CR Institute of Commerce Court. Run the petition.
Yes. You are for the petitioner.
Yes.
Who is for the responding?
I for the state.
Oh. It is also CRL.
It's CR.
Sorry, yeah. Please come here. My list. Oh. Yes. What happened to this matter?
Sir, it's come.
What you have challenged?
I have challenged both the judgment of the court below as well as the session judge, by virtue of which the trial court has convicted me for an offence punishable under section 420 of Indian Penal Code. The prosecution allegation was not that I applied for a particular post. In the application form, there was some interpolation as regards.
In division, you have challenged.
Yes, my lord. Good. Appellate.
Challenge the concurrent finding. Trial court
That's right,
convicted.
That's right. That's right. Because there's no scope in second appeal.
Will you make it second appeal?
It can't be done. Can't be done. That's a whole thing. So criminal remedy, proper remedy.
Will you make it a second appeal?
Can't be done in criminal. Civilly, it's permissible under 100 CPC. My lord knows it. But so far as
So what revision court will do?
not the or the it's an application under.
Actually, court of division should not enter into the
Evidence.
evidence.
Absolutely,
Yes,
absolutely. There is a limitations to that. I can understand.
Limitation to that.
Absolutely. But Lordship, if I could show that the trial court as
The
well.
procedural irregularity or
Absolutely.
anything
Absolutely.
you saw us.
Absolutely.
Yes.
No, I'll just show. Now to see the trial court judgment. Now, may I place the judgment of the trial court? Lord?
Trial court, yes, page
Start 118.
118.
If I could demonstrate before this court, Lord, that the court below misappreciated the evidence on record, then the judgment smacks from the voice of perversity. Then under Article 227, read with 401, this court is vested with the power to go into those aspects. Reappreciation is, I can understand those lines of judgments. Even in civil also, that's the position. Second appeal, no reappreciation.
Yes.
If there is a misreading of evidence, if there is a misinterpretation of a document, the section 100 CPC is open, that gate is open. So it is akin to something like that only. But if I could show, my lordship, that the evidence which they have placed before the court below by the trial court, which has been misappreciated by the trial court and which has been affirmed by the session judge, this becomes a subject matter of a revision before this court under Article 227, read with 401 of CRPC. There is a because I have been convicted. The allegations of the prosecution rest with this case, my lordship, that when I made an application for appointment, application for job, there is an interpolation with regard to my date of birth. Lordship, the assistance of expert was sought for before the court below. Lordship, the expert came. But the expert during the evidence have clearly said that the interpolation date of birth, based on which the entire allegation was foisted against my client, in no way could accused be attributed. I have not been implicated. The expert have clearly said, unequivocally in evidence, said that accused have not interpolated. This matter was missed by the court below. And the appellate court, Lordship, it's endorsed the trial court's sentence because the words were borrowed by the session judge. Without applying an application of mind, there is no total non-application of mind.
I have read the record,
My lord,
this record.
my lord,
Your main contention,
Hello.
made thrust of your argument is
my
that
lord.
it has not been proved that it is you who has
Absolutely,
interpolated.
absolutely,
Your
absolutely.
entire case is that.
Rest on that, absolutely.
It is a fact that it was interpolated and there was some overwritten,
Absolutely.
something was overwritten, but
Lord.
it has not been proved.
Absolutely. Secondly, my lord, there is
But 471 use.
I've not, there's a wrongful gain. I've not got the job. I've not got the job. That's the thing, my lord. I could have understand documents were created. I could get the job, wrongful gain, I can understand.
There are subsidies. Admittedly, you have used where it is there shall be reduced to the upper age limit
My lord,
in service.
my lord, my lord,
Ultimate result.
my lord.
Result in a wrongful gain.
These are the allegations. If I take my loss to the evidence of the expert, GQD, Lord, it's very clear that comes to my right. Prosecution visibly failed.
Expert evidence is opinion in nature. He will not come here to implicate anyone.
Absolutely.
He will come with a evidence which is advisory in
My
nature,
lordship,
only to apprise the
my
court
lord.
that whether, according to the expert opinion, it has been interpolated or
My
not.
lord.
Except this, he will not. He has no personal knowledge to the.
Absolutely. But there was
incident.
other evidence also, my lord. There were no other evidence implicating me for the said act. There was no evidence as such. I can show, my lord, one after other. But since this is coming for the first time, and I've been asked by the session judge to surrender before the court below, my lordship, the order needs to be straight from its operation because it was moved at principal.
No, I am disposing of
My lord,
you say.
My lord,
Eh,
my lord, in
if I
that case,
can't today, I shall reserve the judgment or fix another date for passing for
my
order.
lord. So, my lord, I'll take my lord to the impugned judgment.
Including
118, page 118.
118.
118.
Yes,
I'm just placing this judgment of the court, trial court.
yes. 118.
Lord.
You will again invite us the court to enter into the evidence.
My lord, no, my lord.
Ultimately.
No, my lord, this has to be done. This exercise has to be done. My lord,
Okay.
this has to be done.
Fact, so far my knowledge goes that you applied for a particular post constable or anything
My
like
lord,
that. Here date of birth you have written in the form also.
my lord,
1978.
my lord.
But actually your date of birth is the year of birth 1976.
Absolutely. Absolutely. That's
It
an
is.
allegation.
I read it
No.
earlier. Yes.
Well, I'll
Okay.
take my loss to not the entire judgment I will place.
Yes.
I'll just
Relevant portion.
relevant portion. Page 121, running page
121.
121, internal page is 4 of the trial court judgment.
Okay.
Let us, my lordship, start with third paragraph. Let us.
Yes.
Let us now look into the oral evidence given by the prosecution witnesses, coupled with documentary evidence, and consider whether by their evidence the charge against the accused person has been proved beyond all reasonable doubt. That tampering of date of birth of accused in the school certificate will admit for no doubt. Even it appears in naked eye that the digit 8 in the student transfer certificate bearing serial number 678/97 exhibit 6 has been tampered. And so the word 8, the government examiner of question documents have given clear opinion that the figure 8 has been written in student transfer certificate as 6. After erasing the original figure, and existing writing 8 has been written after erasing and altering the original writing 6 in the student transfer certificate. It is not necessary to dilate on this part of prosecution case, as even the accused did not challenge the correctness of this evidence. On 27/9/1999, PW1 KRR Nair, the chief forest officer, was the chairman of the recruitment board for recruiting the drivers for the fire brigade. He verified the testimonial of the accused and found that on the transfer certificate, employment exchange card, and driving license, the date and month of the birth of accused remained the same, but the last digit of the year has been tampered by making it as 8. He reported the fact to the DIG, who advised him to inquire the matter from the concerned school of accused. Accordingly, PW1 deputed PW2 Jagdish Verma SI to inquire the matter. Jagdish Verma brought a certificate from principal of this concerned school, wherefrom it was found that the date of birth of accused is 24/5/1976. On the basis of report of PWs, the case was lodged against the accused. In his cross-examination, PW1 answered in affirmative that accused appeared before the recruitment board headed by him. This witness proved his signature on the recruitment forms of the candidates at the time of taking physical measurement and scrutinizing certificates of the candidate on 27/9/99. He noted the heights and chest of measurement of accused by his own handwriting and also put his signature therein. So the presence of PW1 at the time of physical measurement of accused and verification of the document is proved. PW2 SI Jagdish Verma has corroborated the aforesaid testimonial of PW1 and has stated that he was instructed by PW1 to verify the date of birth of the accused person from his alma matter. PW1 went to the school from which the accused obtained his transfer certificate. He met the vice principal, Sri JB Singh of the said school, and the said JB Singh issued a certificate relating to the date of birth of accused. So it is proved that as per the instruction of PW1, PW2 went to the school of accused and collected a certificate from principal from the said school. The successful inquiry of PW2 set the criminal motion into motion, law into motion. PW3, SIBS Pillai received a written report from Chief Fire Officer and he chalked out the formal affair. PW4, JB Singh, Vice Principal of Government Senior Secondary School, Wimberley, readily noticed tampering in the column of date of birth in the transfer certificate of the accused when the same was shown to him. He scrutinized the transfer certificate of the accused with the information register and withdrawal register and also the counter file of TC book and found that the said TC was tampered in respect of date of birth of the accused. He issued a certificate regarding the actual date of birth of the accused as noted in the school register and handed over the same to the police personnel. He identified the forged transfer certificate and its counterfile which bears the same number and date as written in TC and was kept in school. Both were issued by the same person in his official capacity. PW5, Srimati P.K. Vijay Lakshmi, Employment Exchange Officers from the investigator procured the employment registration card of the accused. PW6, T. Suresh, SI of Fire Station, was committee member of the recruitment board for recruitment of 6 fire brigade drivers. After physical measurement test, the accused was among the 34 successful candidates who were called for scrutinizing their certificates. The accused produced before them his transfer certificate, employment exchange card, and local certificate for verification. So in all the certificates, the date of birth of the accused appeared as 24/5/1978. But on careful scrutiny, it appears to them that the digit 8 was overwritten and got tampered. On transfer certificate, the word 8 also overwritten and got tampered. Noticing such overwriting, a reasonable doubt was created in their mind and they reported the matter to their higher authority. PW6 fully corroborated the version of prosecution which is narrated in the first information report. The defense dared not to challenge the presence of this witness at the time of selection test of the accused. PW7 SK Singh, retired principal of Model Senior Secondary School, given a biodata to the police. Police took signature of the accused on 15 sheets in presence of PW8 Ablu Kumar, who is a friend of the accused. Police seized the counterfile book of TC bearing number so-and-so of the year 1997 in presence of PW9 Suman Devi. This witness identified the seized TC register. PW10 Lognathan, Assistant Government Examiner of Question Document, has the MSc degree in Forensic Science. He is adequately qualified as an expert. He proved his opinion and report as Exhibit 12. The defense has not challenged his report so as it stands as it is. Arvind Rai, Inspector of Police, Pritam Singh, Head Constable in the Fire Service, have been examined as PW Lan and PW. They are only official witnesses and their evidence need not to be explained. PW13, Imamuddin, SI of Police, seized the counterfile of the TC from Government Secondary School, Wimberley during investigation. He identified the seized counterfile being the counterfile of TC which was produced by the accused. He handed over the case record for the investigation of case to SI Manjit Singh, who was examined as PW14. PW14 obtained the handwriting of the accused for comparison, sent to same to Government Examiner of Question Document, Kolkata. He also received opinion from the Government Examiner of Question Document, Kolkata. On completion of investigation, he submitted the case diary along with the connected papers to SHO to the concerned police station for submitting charge sheet against the accused. PW1 and Rashid Datt and SHO filed charge sheet against the accused in the court. This is one of those cases where here the end result is a long foregone conclusion, a fait accompli, and time is only the barrier between the inevitable and the lingering uncertainty which pervades all the proceeding judicial in nature. The deposition of PWs are in strict accord with the averments made in FIR. The cross-examination of these witnesses have been effectively ineffective. Reading the deposition in conjunction with the documentary evidence on record.
Come to that, there is no delay in the last paragraph. There is no
There is no
delay.
delay in lodging the FIR
FIR.
information report.
Statement of all prosecution witnesses are quite
Quite
consistent, and there is no contradiction apparent in that case.
Yes.
It is the main basis of
Mine.
this.
The oral evidence is fully corroborated by the documentary evidence.
Hmm.
It appears from the certificate given by the principal government senior secondary school, Wimbledon, South Andaman, dated 29/9/99, in his official capacity that the date of birth of the accused is 24/5/1976, and the transfer certificate was issued from his institution on 23/9/1997, bearing TC number so and so to that effect. In counterpart of the student transfer certificate exhibit 5, which is seized by the police, the date of birth of the accused is recorded as 24/5/1976, is as recorded in the school admission and withdrawal register. So in the student transfer certificate submitted by the accused, his date of birth is written as 24/5/1978, and in counterpart of the same student transfer certificate bearing the same serial number 678/97, the date of birth of the accused is written as 24/5/1976. It is crystal clear that the date of birth as written in the student transfer certificate bearing serial number so and so submitted by the accused has been tampered. It is also very clear that the only digit 8 in number and in word has been tampered in exhibit 6 to show that the date of birth of the accused is 24/5/1978. During argument, Learned APP has submitted that the case of the prosecution is based upon documentary evidence coupled with oral evidence of the prosecution witness, and all the prosecution witnesses have stated that the transfer certificate has been tampered. PW2 went to the school of accused to separate the grain from chaff and found the date of birth of accused in the school register as 24/5/1976. After receiving the information from PW2, PW1, the chairman of the recruitment committee, lodged the first information report after satisfying about the committing the alleged offence by the accused. Learned APP has further submitted that from the evidence, it is proved beyond any shadow of doubt that the original date of birth of the accused is 24/5/1976, and he is who has altered digit 6 in his transfer certificate. Learned APP paid attention of this court regarding paragraph 7 and 8 of the report of the expert, exhibit 12, wherefrom it appears that the existing writing 8 in the red ink portion marked Q3 has been written after erasing and altering original writing 6. These documents has been used by the accused before the selection authority. According to Learned APP, the prosecution has been able to prove the case of prosecution beyond reasonable doubt. Learned advocate for the accused has submitted during argument there is no dishonest intention on the part of the accused to commit the offence. If his date of birth is 24/5/1976, then also the accused was entitled for the post. If it is assumed that the date of birth of the accused is 24/5/1976, the upper age limit was not barred to him at the recruitment for the post of constable driver in Andaman and Nicobar Fire Service. According to Learned advocate for the accused was not under pressing need to rectify his date of birth in order to qualify for the said post. According to him, no motive of accused has been established in tampering his date of birth. I am not agree with such contention of Learned advocate for the accused. To me, the motive of the accused for committing the offence can be well presumed. If the date of birth of the accused is 24/5/1978, instead of 24/5/1970, he will have an advantage of remaining in service for another 2 years. During argument, Learned APP has submitted that the accused has tampered his date of birth in conformity with other documents. Though the tampering of the date of birth of the accused in his employment exchange card or his driving license is not the subject matter of this judgment, but it can easily be said that his date of birth is written on those documents as 24/5/1978. It may be presumed safely that the accused has tampered his date of birth in school transfer certificate to make the same at par with the employment exchange card and driving license. To me, motive of tampering of date of birth in school certificate is fully established. The next point urged by Learned advocate for the accused that in paragraph 7, 8, 9, 10, 11 of the expert report exhibit 12, it is opined by the examiners of the question document that it has not been possible to say that who made the alteration and the overwriting in the document 4. At this court, learned advocate for the accused has submitted that there is no opinion of the expert that the accused has made alteration and obligor overwriting in the question document. It is no doubt that so far as the evidence about the forgery of 1 digit 8 on the student transfer is concerned, there is no evidence except the fact that the said digit is forged. And the further fact that the student transfer certificate is used for the purpose of proving the date of birth of the accused. From these facts, an inference could safely be drawn that it was the accused who got his date of birth forged on his document, as it was he who used it to believe the employer of his date of birth as 24/5/1978. It is no doubt true that there is no evidence as to who forged the date of birth on the student transfer certificate, but the circumstances indicate about which lead the only inference that it was the accused who got the date of birth forged on the student transfer certificate. The further argument for the accused was that the document was submitted before the selection committee, and at that time tampering with the document may be done to disqualify the accused. The mischief may be done to debar the accused from recruitment in order to push someone else. It is the story of the prosecution case that this accused submitted forged transfer certificates before the selection committee. After detecting the forgery, the chairman of the selection committee took immediate steps to bring the matter into the notice of DIG, and he also sent a police personnel to the school of the accused, from where the accused procured his transfer certificate. I have already come to the conclusion that the date of birth of the accused person has been tampered and made as 24/5/1978 in consonance with the date of birth written in the employment exchange card and driving license. If any person has committed the forgery to debar the accused from recruitment, the exact date written in other documents may not be followed. In this case, the date of birth forged in the transfer certificate is precisely the date of birth mentioned in the application form of the accused person and also in other documents submitted by the accused person before the selection committee. When a specific question was put to the accused under section 313 of the Code of Criminal Procedure by this court regarding the alleged tampering of date of birth, the accused denied and the alleged tampering. He has not taken the plea that the alleged tampering has been done by any other person. In any case, the whole story about submitting the forged transfer certificate by the accused to the selection committee regarding his age is so natural and probable that it would be difficult to accept that the alleged forgery is committed by some other person. The further argument of the accused persons was that the accused was not benefited by the document forged. In my opinion, the accused submitted the forged document for his personal benefit. Scratching of 2 years of service career is obviously beneficial for the accused. The case of Jibral Diwan versus State of Maharashtra 1997 6 Supreme Court cases 499, upon which accused relied, is that the appellant alleged the forged letter of head of minister and his co-accused who allegedly forged the letter was acquitted from case. The Honorable Apex Court held that by delivery of forged letter, there is neither any wrongful gain to anyone or any wrongful loss to another, and the act of appellant would not thus be termed to have dishonesty, and there being an absence of harms to any person in body, mind, reputation, charge under section 417 also misplaced. The finding reached by the Honorable Apex Court in the judgment cited on behalf of the accused being a finding conformed to the facts and circumstance of that particular case has no negative impact whatsoever on the present admissibility.
Okay, now, if according to the line of your argument, it is here that it has not been proved that it is the accused person who interpolated the document. It is your main thing. So there is no basis of convicting the accused person. Yes. Actually, what has been proved, if we summarize, it has been proved that the document, maybe a transfer certificate or other documents, had been interpolated. It has been proved that actual date of birth, I couldn't recollect, the year of birth 1976. It has been proved. From the school, it has been proved. And the principal concerned had also deposed.
Certified.
Has substantiated that actual year of birth would be 1976. Now, it has also been proved that, as I have stated, that it has been interpolated. That has been proved, admitted. So interpolation has proved. Now, it is also has proved that it is you who applied annexing those documents. And in your application form, you specifically mentioned your year of birth 1978. It has been proved. Now, actually, entire fact cannot come before the court. court has the liberty to, and the court has the duty to make inference upon the proven fact. Entire fact will not come. Court, basically, court is manned by a person who has no personal knowledge. Now, certain fact will come which should be proved by evidence by the parties. Then, based on this proven fact, now court will infer that if this fact is proved that actual year of birth 1976, interpolation was given, presentation of this document is proved. Now, whether the inference which the court has drawn is wrong.
But I'm not on that line. My point of argument is little bit different. I'm saying, these sequence which my lord have just said, it's on record. I cannot travel beyond the document.
No.
It's there already on record.
Yes,
It's there.
yes.
And the scope of this court under Article 220 is very, very limited.
Very limited.
Very limited. I cannot bother my lord. I know.
No, I am entering into my to ascertain your fact
Lord.
whether the trial court judgment is based on evidence or not.
My lord, my point of argument would be strictly on the point that there is no wrongful gain to me, my lord. The apex court in this judgment of 1997, 6 Supreme Court cases 499, which I would rely here also.
Okay, now if this year of birth is accepted by your employer, whether your service period will be expanded or not.
It would be, my lordship. But I'm not being given a job. No, I could have understand based on these documents, interpreted documents. I've applied it. I secured the job. I was working. I can understand that line. But that was not the case of prosecution before the court below. The prosecution case simply rests with these facts. I placed a document which contained an interpolation so far as 6 is concerned. Instead of 1976, there is 1978. It was the further prosecution case that had this document been accepted by the employer department, had he been given a service, his retirement would be plus 2 more.
Yes.
Plus 2 more.
Yes.
But these facts never occurred. My point of argument is, lordship, these facts never occurred. If that be the case, the very genesis, the very basis based on which I've been entangled in the case goes. That's my point of argument. Aptly on the point, lordship, the apex court in this.
Cheating, and ingredients of the cheating is that I shall get some wrongful gain at the cost of wrongful loss of any person.
Absolutely. Absolutely.
If I cheat yourself, you
Absolutely.
today,
My lord.
that means you will suffer wrongful loss, while I shall get wrongful gain.
Absolutely. Absolutely.
Now it is the government will suffer, that he will be forced to stay in your service for more than 2 years,
My lord,
for 2 years more.
my lord, this has not happened. That's my case. I could have understand that I got the job based on this interpolated document. 1 year lapsed, these facts they detected, FIR lodged, I've been put behind bar, trial taken place, I have no case. I can understand that. But this link is missing here. My point of argument is, lordship, that's the very core issue, lordship, that goes to the very prosecution case, which scuttled on the prosecution case, which both court below and the first.
That means your offense is cheating. Offense of cheating is not committed.
Complete. That is the point. That is my point of argument, my lord.
Okay.
Though, as I've been saying, my lordship, those records which is on record, I cannot travel beyond this there. I do understand. But this argument of mine at this juncture, with the evidence of the expert, I can understand, my lordship, the legal value of a report. It's simply tentative in nature. It's subject to scrutiny by a court below. I can understand. And Lord, the Supreme Court has time and again said, the expert opinion should not be taken.
It is advisory and opinion.
Absolutely.
Expert.
It has no conclusive document. It's not a conclusive evidence. It's subject to scrutiny by a court.
Yes.
Feels it, this has to be taken in a given case, it would take. Solitary on the basis of an expert evidence, one cannot be convicted. Those lines of judgments are also there, Lord. But my point of argument, Lord, kindly appreciate. Lord, kindly see, the court below has imprisoned me. I'll just paste at page 415, Lord. 6 months for 468 and 3 months for 471. And my lord would see this case was.
And concurrently.
Concurrently.
Actually 3 months.
My lord. But this case was initiated way back in the year 1999. The judgment was rendered 2013. Look, this period of trial,
And you have undergone a long, long.
There are judgments even on that line.
trial,
Even on that line. The court could have taken a lead. Look, that's what I'm saying, Lordship. I am arguing before this court today, being the ultimate court of this island, forcefully would not change the case. But what can be done, Lordship? It's based on record. But at the same time, there is a grey line of argument, Lord, I would say. The grey line would be offense has not been committed. Offense has not, if it is not committed, I could not have been entangled in the case, Lordship. No trial could have been taken place. As I've said just now, at the cost of repetition, Lordship, I could have understand the prosecution case. Yes, with this fact, I got the job. I secured, I have been paid with a salary. There is a public money exchequer. Government paid money. There's a wrongful loss. I have gained it. I could have understand these, but this is not the prosecution case out and out.
Attempt is also
But this
offense. Actually, offense stage is past motive. It will come motive.
I understand.
Then preparation.
Preparation.
Then attempt. If attempt is successful, offense is committed. And if attempt not successful, then offense is not committed. But attempt, if coupled with some incriminatory act, will be offense. I am trying to kill you. Okay. I made attempt. I prepared. I suppose I have purchased one knife that I shall kill Mr. Joypal. Then I attempt with knife. I bounce upon you, but someone intervened. I could not complete my mission. Attempt is there, coupled with some act on my part. Then there must be offense.
But Lord, kindly consider this judgment of the Supreme Court. It's a celebrated judgment on the point.
Yes.
I'll place it.
Yes.
Just place it.
Yes.
Once I conclude the argument with regard to the material conclude.
Yes.
So, Lordship, my second point was, the first point is this, that no offense has been completed. Secondly, I have not been implicated even, Lord, on the face value of the expert report.
No.
Expert nowhere said that
Yes.
it's me who has interpolated. Nowhere it said.
Yes.
But thirdly, a very humanitarian submission was advanced before the court below to invoke the provisions of Probation of Offenders Act. Lord, even that was not considered. Even that was not considered.
Okay.
So mainly on these 3 points, I argue, my Lordship, my Lord has given me illustration just now. My Lord, kindly, my Lord, may I say one thing, my Lord? He has undergone the trial for these many years, my Lord. I understand, my Lordship, beyond records, I cannot travel. What is there, it's there. What run is his mind, he plays the document, but my point of argument, offense has not been committed. Lord, kindly consider this judgment. Many of these points,
Okay. That's
some just one second.
everything will be dealt with and complete, no problem. In Indian criminal jurisprudence, one accused person get rights from the very beginning. Bail, then according to his choice, he will be get advocate. Count of arrest would be disclosed to him. Thereafter, in appeal, legal aid service. Then even before conviction or hearing on question of sentence, everything in Indian legal system jurisprudence, it is the accused who gets benefit from the end to end.
Even the Lord knows, Lord.
And he will be treated as an innocent until proven guilty.
My Lord knows, my Lord, this is not would be applying here. But if my Lord knows those lines of judgment which says, if the accused is detained and trial do not take place, he is entitled to get bail.
Yes.
There are judgments. Article 21 has been. There are judgments.
Yes, right to speedy trial also is a right
My Lord,
of an accused.
no trial started. It's consumed considerable period. Nothing done. No progress in the prosecution case. Bail to be granted, even in a grave offense.
Yes.
Those lines of judgment. But trial.
Even in NDPS case, the officer will offer, you search me. You search me. Before I shall start searching you, you please search me. accused will search the officer concerned. Whether anything is lying with him, which can be implanted.
Implanted.
Okay.
But this judgment,
Hmm.
I'm just placing it. It's 1997, same one which I
Hmm.
quote, right? I'll just place that paragraph. Just one second. It's paragraph 3, Manoj.
Hmm.
Paragraph, I'm just placing paragraph. It bears repetition that the appellant was not the forger of those documents. Section 471 enjoins that whoever fraudulently or dishonestly uses a genuine any document which he knows or has reason to believe to be a forged document shall be punished in the same manner as if he had forged such document. Section 465 provides that whosoever commits forgery shall be punished with imprisonment of either description for term which may extend to 2 years or with fine or with both. Now the words dishonestly and fraudulently have been defined respectively in section 24 and 25 of Indian Penal Code. Dishonestly has been defined to mean that whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to do that thing dishonestly. The word fraudulently has been defined to mean that a person is said to do a thing fraudulently if it does that thing with the intent to defraud, but not otherwise. This court in S. Datta versus State of UP has explained the word intent to defraud as being not synonymous with the word intent to deceive. It requires some more action resulting in disadvantage, which, but for the deception the person defrauded would have avoided. Hereby, the delivery of forged letters, there is neither any wrongful gain to anyone nor any wrongful loss to another. The act of appellant could not thus be termed to have been done dishonestly. Likewise, the appellant cannot be said to have any intention to defraud because his action resulted in no disadvantage to anyone, which but for the deception the person defrauded would have acted otherwise. The basic ingredients of the act done dishonestly or fraudulently being missing, the charge under section 471 read with 465 was totally misplaced and High Court fell in error in committing the appellant on those charges. But here also, the accused persons were tampered the letterhead of the concerned ministry, it was placed. Akin to this case, based on the record, documents are placed. But the apex court heavily held there is no wrongful gain and loss. So those sections would not kindly consider these judgments. My point of arguments mainly rests with this judgment and the point which I've argued. And not the last but not the least, Lordship, the court ought to have exercised the power under the Prohibition of Offenders Act. Not
Okay.
these are my points of argument.
Okay.
And I pray for to allow here.
Lordship, may I please, Lordship? Lordship, first, the concurrent finding, that is first appellate court, cannot be reappreciated again, Lordship. First, settled principle of law. First point, maintainability, Lordship. Even though Lordship had heard regarding the merit of this judgment, that impugned judgment, Lordship kindly come to the judgment passed by the first appellate court. How the appellate court has scrutinized, appreciated, and discussed about that order of conviction passed by the judicial magistrate, Lordship. Kindly come to the page number, internal page number 140, Lordship, of the application of the petitioner. The order and judgment of the session judge, Lordship.
Yes.
Lordship. Page number, second page. Number
Internal
two.
page 7.
Sir, internal page I am not getting, not clear.
At the top, internal page.
No.
Yes.
Then second para, the brief fact of the case.
Oh, you will go back. Yes.
No, fact, yes.
Yes. Yes.
Just that is very vital regarding mens rea, motive. We have to see the nature of the offense. Offense from where it was started. So brief fact is the very vital. The brief fact of the case is that in order to fill up 6 vacancies of constable driver in Andaman and Nicobar Fire Service, 40 candidates were sponsored by the local employment exchange. On 27 September 1999, the candidates appeared before the selection board for physical measurement test. The appellant herein was one among the other candidates who cleared physical endurance test. It means since beginning he is appearing. Since beginning First physical test, measurement test, he passed. He passed since beginning. It means it is within his knowledge. The post is vacant, 6th post. I have to get a job. I have to get a job. Then, Lordship, accordingly, he was allowed to join the trade test. At that time of scrutiny of his application and original certificates like student certificates, I am reading, Lordship. Local certificate, employment exchange, identity card, and driving license. It was noticed by the selection committee that his date of birth was entered as 24th May 1978 in employment exchange card, driving license, and in student transfer certificate serial number such as such, issued by the principal government senior secondary school, Umliganj, South Andaman in the NT 1978. Regarding the date of birth, the figure 8 was found to be tampered. So here 6 original 1976 that was tampered and converted, deleted, alteration, 8 was inserted. 8 was inserted. Lordship, first we have to see, Lordship, if the forgery is not attracting, that it is not within the knowledge of the accused convicted person. Lordship, all the documents, relevant documents, are in the name of this person's application. First, it was from his possession, Lordship. Lordship, I have passed LLB, Lordship. I am using that certificate, Lordship. It is my knowledge. I have passed the LLB. Then applied for a job, Lordship. Then I have used it after alteration from 6 to 8 for getting some benefits. What is the benefit in future for +2, not for getting a job? The case of the prosecution before the learned court below, it was not a case of the prosecution that what was the intention that after 2 years benefit will be get. The court found, the trial court as well as the concurrent court, that is first appellant, the intention clearly can be presumed under section 106 of the Evidence Act, Lordship. Very important part is 106. Because the defense taken by the convicted persons that it was not tampered by me. Kindly, Lordship, look into the presumption under section 106 of the Evidence Act. All the documents belongs to me. I have applied for a job. During final recruitment process, it was found that the number has been forged. So, the trial court rightly came into conclusion under section 106 of the Evidence Act, the presumption, because it is not other documents that I have used the document of Mr. Jaipal. My document, I have used it. Then 471. And what 463 saying? Kindly come to the definition of the section 463, Lordship. That there is no mens rea, no intention. Kindly come to the definition of 463, forgery.
Yes.
May I read, Lordship?
Yeah.
Whoever makes any false documents or false electronic record or part of a document or electronic record with intent to cause damage or injury to the public or to any person or to support any claim or title or to cause any person to part with property or to enter into any express or implied contract or with intent to commit fraud or that fraud may be committed, commits forgery, Lordship. Lordship, the documents found that is altered from 6 to 8. The question, who altered it? Documents is my name, Lordship. I possess my qualification documents all. I applied, I fill up the form for getting a job. I use my transfer certificate. It is not within the knowledge, can I say? It is not documents that I have used some others document. My documents, I used it. Physical test, I have been passed. In the final recruitment process, it was found that during verification, my TC certificate have been tampered. So court, the trial court as well as the
No,
Appli-
whether any judgment or anything on this point that if my documents, which is lying in my possession,
Lordship,
is found to be interpolated, it would be presumed that it is me who has done it.
Lordship, judgment, as per my opinion, Lordship, it is not record at all, Lordship. Under 106 Evidence Act, Lordship, presumption can be taken. That was taken by the trial court. 106. Because it is the knowledge, Lordship, mens rea, intention, motive of any accused persons, I cannot say at this stage. Lordship already expressed preparation, attempt, then commission of the offence, Lordship. From the beginning, Lordship, court has rightly came to the conclusion under section 106 of the Evidence Act. Because I have used it, Lordship. My document, then who has tampered it? Whether any defense has been taken by the accused before the trial court? Not at all. Not at all. That no, I have not tampered. My documents were lying with another house in the locker of my relatives or neighbors. Somebody has tampered it. Then return me, I have used it for getting a job. Lordship, kindly see the mens rea motive since beginning. So London trial court has rightly came into the conclusion. Yes, it is your document. You used it for getting a job. Alteration, the digit 6 from to 8. First, second part. Lordship, he has filled up the form application also. For telling that part, he has written as a 1978. Thereafter, that alteration 8. So kindly see the mens rea, intention since beginning. At this stage, if I will say, I don't know who has tampered it, Lordship. It cannot be seen. My certificate, Lordship. I used to keep my certificates after getting a proper qualification. It is within my knowledge that I have passed 12th or LLB. I have applied for a job. In physical verification, I have passed it. In final verification process, it was found. So 463 forgery, I have read out the definition. Then 471 Lordship, using a false document. If the London Council has argued that who have forged it, forgery cannot be said, that was not proved. Then 471, if for sake of argument. Now who has used it? The prosecution has able to prove before the trial court. Who used it? False document, because the expert report, that is P12, specifically stated, yes, 6 digits have been tampered. It was written as 8 from 1976 to 1978.
Yes.
So, Lordship, here, first appellate court, kindly come to the judgment, how it has been discussed, nicely discussed. Then come to the next. I am come to the last question. Then points for consideration. Lordship, page number 5 of the judgment of the application.
Yes.
Numbering I am not in getting. Lordship, got
Okay.
points for consideration.
Yes, yes.
Then decision with reason, Lordship. May I read, Lordship? Decision with the reason. Advocate appearing on behalf of the convict submit before this court. The convict applied for recruitment of constable driver in Andaman Nicobar Fire Services. It is alleged the date of birth in his transfer certificate, that is Exhibit 6, was tampered and it was written as a 24th May 1978 instead of 24 May 1976. He further submitted that it has been alleged that it was detected at the time of verification of his certificate during the final scrutiny of those certificates by committee. He further submitted that the report of exhibit, that is Exhibit 12, that is expert report, Lordship, state that number 6 has been altered as 8 and its number as well as its word. It has also been submitted, the convict submitted the correct transfer certificate, but he does not know who tampered the same. Who tampered the same? He also submitted the said original certificate was in custody of concerned department where anyone would have tampered it, which is out of the knowledge of this convict. Lordship, during verification, final, I have produced it. It was not lying in the office concern. Original have to be produced at the time of final verification. Then last portion. He further submitted the from expert report. It appears that he failed to tell that tampered the same. If that be so, then 468 as well as 471 penal code does not attract against this convict, and the landed trial court, without considering all these facts and circumstances, convicted him in his case. He also submitted that if the date of birth 24 May 1976 be taken into consideration, in that case this convict was eligible for the examination, then why he will temper the same number from 6 to 8? He further submitted 3 judgments. This have been cited now, Lordship. 3 judgments also submitted before the first appellate. That was also discussed. That was this next page is discussed. Then second paragraph of the next page, Lordship, page number 7. On the other hand, PP submitted before this court that the document in question, that is Exhibit 6, was in the custody of the convict. He submitted the same before the authority at the time of recruitment process. Hence, under section 106 of the Evidence Act, it is the duty of the convict to explain that how the said tampering took place. He also submitted that at the time of trial, this plea has not been taken from the side of the convict that the said exhibit, that is Exhibit 6, was tampered when it was in custody of the concerned department where he submitted for recruitment. He further submitted that as per Exhibit 12, that is report of expert, it is very much clear the expert in his report clearly stated the said figure in its number and its word was tempered, and said number 8 was also written in letter, that is 8. So in numbering also had been changed, Lordship, which clearly showed that the convict tempered the same for increasing his length of service for 2 years by forging the said documents. So see the intention, Lordship. I have altered from 6 to 8 first. Then in words, I also altered for lending service, benefit of 2 plus. I used since beginning, Lordship. Then next paragraph. He further submitted that the section level against the convict apprentice for using the document as a forced document, and it is not the case that who tempered the same. He also, so my case before the trial court, Lordship, who tempered the document, that is the not case of the prosecution. Who tempered it? For attraction of ingredients of section 463, Lordship, who tempered it? It is not a burden of the prosecution that who tempered it. The prosecution found the document have been tampered and have been used by the convict himself. So case started, Lordship. It is the duty of the accused to take some presumption in favor of him. That denial is there, that who tempered, I don't know. Then who
Yes.
tempered it?
Yes.
He pointed out second clause of section 464 of Indian Code in support his contention. He further submitted that all documents have been submitted from side of convict, and since the date of birth of this convict was written as 24th May 1978 in his driving license and employment exchange card, that is why in order to keep parity of those documents, this tampering was done. And after the said tampering, this convict submitted the same before the authority. Hence, he is guilty of the offence level against him. The London trial court has rightly convicted the Rajesh Sundarrao in this case, which was before the trial court. He also submitted a judgment cited. The cited have been discussed, Lordship. I will not repeat again, Lordship. Kindly come to the next page, that is page number 9.
Court held that onus was lying
Yes.
upon him to,
Yes, proof.
to show who tempered it.
Tempered it, yes. Then next page, Lordship, page number 9. First, second, third para, Lordship. Third para. On perusal of entire record. On perusal of entire record and judgment by the London trial court, I find that at the time of his examination under section 313 CRPC, he did not take plea that the submitted a right document, but it was a tampered when it was in custody of the authority. No, only denials, false case under section 313 CRPC. Nothing, no evidence adduced. Here, I would like to mention that suppose he submitted the untempered document to the authority, but it is the normal phenomenon that before submitting original document, a person generally keep the xerox of the said original document. If that be so, then he should have produced the xerox copy of the said document before the London trial court to show that he had deposited untempered document. Next page. And this is the xerox copy of the same. Then plea could have been from his side that when he deposited the same before the authority, it was written as 24th May 1976, but the same was tempered later on. The convict also did not file any xerox copy of such document before this court, which clearly showed that he submitted tampered document before the authority during process of recruitment. If that be so, then under section 106 of Evidence Act, onus lies upon him to prove before the court below how the said document have been tampered, as because he was the custodian of the said document before its submission, Lordship. From the expert report, that is exhibit 12, it is very much clear that number 6 has been tampered and its number and word as 8 digit. If that be so, then it can be said that the said tamper transfer certificate has been filed by this convict at the time of recruitment, and its main motive was for increasing the length of service for a period of 2 years. When I perused the judgment of the London Trial Court, I found that he fully discussed all those things in its judgment, and he also discussed in his judgment that if it was done only to bring the said document in consonance of document relating to driving license and employment exchange card. I also find from the judgment, the London Trial Court, that he clearly mentioned that Exhibit 6 was also compared and verified with the school certificate authority, and school authority stated that it is a tampered document after comparing it with counterfoil and document relating to the school. If that be so, then it is very much clear that London Trial Court has rightly passed the judgment holding that the document in question is a false document under section 470 of the Indian Penal Code, and the same was fraudulently and dishonestly used as a genuine document. According, the convict was guilty under section 471 of the Indian Penal Code. London Trial Court also held that the convict had an intention to deceive the selection committee and to secure a benefit or advantage of service life for 2 years more. He tampered his transfer certificate, hence under section 460 of IPC has committed forgery for purpose of cheating. As per the question of application of section 420 of Indian Penal Code is concerned, I found that there was a mens rea of the convict to use that manufactured document as a genuine, and since the document was in his possession, that is why onus lies upon him to prove that how the said document was tampered and by whom it was tampered, as because it is a special fact within his knowledge. As per the applicability of
Yes,
judgment,
not applicable, yes.
Lordship. So let's kindly see the judgment of the trial court, which was already discussed and scrutinized by my learned friend. That judgment already discussed by the first appellate court,
But not applicable.
not applicable.
Distinguishable on.
And appellate court, everything has been discussed regarding the ingredient section 463 forgery, using up those documents, regarding mens rea, intention, motive, what was the intention for plus 2? For plus 2. So since beginning, Lordship, at this stage, if I will say my document, TC certificate, I don't know who tampered it, then why he did not brought any witnesses evidence before the trial court? No, 106 Evidence Act presumption have been drawn, Lordship, and concurrent finding. It is not like that first appellate court not discussed about the evidence which was recorded before the trial court, who have passed the impugned judgment, that is a conviction. Everything had been discussed. Everything regarding mens rea, everything. So at this stage, first maintainability regarding that concurrent finding cannot be reappreciated at this stage. First, second part also, on merit also, I have argued that no, there was a mens rea, intention, motive for commission of the offence. So application is liable to be rejected, Lordship.
Just, I would add one judge.
Yes.
So it followed on considering the submission of the prosecutor, overrule my points of argument. Then Lord, this judgment may kindly be considered more particularly. It's reported in 1985 three Supreme Court cases 658, Pravan Kumar versus State of Uttar Pradesh. Just I would know what has happened here. A clerk has interpolated the bail bond. He was attached with an advocate. He interpolated the signature of advocate. He interpolated the handwriting of surety. It was used. Bail bond was accepted. Trial took. It went up till High Court. High Court said nothing doing. Supreme Court was approved. Supreme Court said, put see paragraph 4. We have the provisions of Appendix Act benefit was not extended, but at paragraph 4, what Apex Court held, we have heard learned counsel for the parties on this appeal, and we are satisfied that the High Court is right in maintaining the conviction of the appellant. We are also satisfied that this is not a case where the benefit of section 360 of CR Code of Criminal Procedure should be extended to the appellant. The offence is serious in one, and we do not think that the appellant should be entitled to release on probation of good conduct. But having regard to all the circumstances of the case, including the circumstances the offence was committed as long as 1968, and the appellant has already suffered sufficiently, we reduce the sentence of imprisonment imposed on him to the period already undergone. We are told that the appellant has already served 9 months in jail.
You are in jail.
No, I was there in jail because when the FIR was initiated, I was taken into custody.
For how many days you are in?
2 months. For 2 months. So if not holds that, do not put good, but these judgment may finally be.
Actually, at this stage, is a benefit of set off has been given.
Set off has been given.
Uh,
Set off has been given.
If it is decided against you, we will go
Absolutely.
1 month.
My lord, my lord.
1 month and 4,000.
My lord, my lord. It's not humble.
Oh, okay. Acha. Yeah.
Obliged, Lord.
Mr. Joypal, learned advocate appealing for the petitioner, and Mr. Kormokal, learned advocate appealing for the respondent, have concluded their arguments. ঠিক আছে, judgment is up.
I'm ready.
Actually, আচ্ছা এইটা ইয়ে করে দেবেন তো। Very good argument. I have enjoyed it. Next.
Item 2, WPA 493 of Parliament 4.
तो कॉपी हमको देगा वो
अरे वहाँ पे डिलीट कर देगा वो।
Yeah.
For the petitioner, my lords.
The last order may be seen, Lord, the petitioner want to delete the
मायने
SHO please.
अच्छा।
Because he says he has no grievances against the.
Six accommodation last.
हमको कॉपी का
Last order. Last order means it's.
क्या आप पार्टी बनाए तो उसको बॉडी बनाया है अरे ये हम अफेयर हो जाता है ना तो बिल तो मिलेगा
No, last order means.
Last order, when their service with regard to the SHO startup.
No.
Camel has
Yeah.
not been served. So they have raised.
No, here you are the petitioner.
I am for the respondent.
You are
The
for the
petitioner,
petitioner.
the
Their allegation is that one contractor also going beyond this periphery of work has constructed.
No, no,
We have.
So yeah, make the contractor as party to these proceedings. I don't know how the.
with respect to contractor as well as with respect to SHO. SHO was already served. However, the last honorable bench has asked for affidavit of service. We have filed the affidavit of service, but the tracking report was not enclosed. So we had prayed for time. My lords,
No, yeah. I am asking whether the presence of the contractor concerned is necessary for adjudication of this petition or not. I am asking you, all of you, to.
Because he is being
He was working under a tender.
we have floated a tender, he is executing the work as the instruction of
The respondents have given instructions, and as per respondents.
But what you have stated? You have stated that you are now trying to shift the burden upon the contractor. We don't know, we such and such, it is the contractor who has done it. I have seen here.
Lords, with respect to the submissions of the petitioners, I am the assisting counsel.
One to 5, 11 and 12, Babita. Respondent 9, 9, only 9.
6, 7, 8 and 9.
6, 7, 8, and 10.
10. Lucky. 6, 7, 11, 12. One to 5 हम बोले यार
7.
Indulgence, my lord.
Huh?
Indulgence, my lord, I'm the counsel only assisting in the counsels on record for filing this writ petition. They intended to argue this matter in physical, but however, they are unable to make it in this circuit. So I'm praying let the matter be fixed in the next circuit because the counsels on record are from Delhi, Delhi and Calcutta. So they are unable to be present before this court.
Regarding service, what you are saying regarding service?
Service,
Brother is now
service,
appearing. Because Previously he was not appearing. As he is
For
appearing.
respondent
Respondent
9, I
nine is
am
now
appearing.
appearing. They were already served. Affidavit of service is on record.
The affidavit of service filed on
Now
behalf
all
of,
are appearing.
Every
Lordship.
party is appearing.
the affidavit of service filed on behalf of the petitioner is taken on record. ঠিক আছে, আপনি ইয়ে করুন। The Mr. Kormakar has entered appearance on behalf of respondent number 9. ঠিক আছে। আচ্ছা। Stop. প্যারা ইয়ে আপনি দিন যে learned advocate for the ইয়ে Mr. Such and such, your name please?
Shahir, Mohammed Shahir. Shahir,
আচ্ছা, মোহাম্মদ সাহিল।
yes.
হ্যাঁ, সাহিল আর কি। Sahil appearing for the petitioner submits that it's a place for accommodation. Place for accommodation. I submit that the Mr. Banerjee will argue. কেটে দিন, ওটা কেটে দিন। Mr. Sahil, learned advocate appearing for the petitioner submits that Mr. Banerjee will argue on behalf of the petitioner. On his petitioner. On behalf of the petitioner, argue in this matter on behalf of the petitioner. We submit that he is not in a position to represent the petitioner as of now. He prays that this matter be placed before the next circuit bench. ঠিক আছে? The learned advocate representing the be placed before the next circuit bench. ঠিক আছে? Learned advocate representing the respondent did not oppose such prayer in view of thereof. ঠিক আছে? Place this matter before the next circuit bench, subject to comma, subject to its convenience.
Grateful.
Next.
Appearances with regard to respondents will be recorded.
Huh?
The appearances with regard to the respondent.
Will be recorded.
Grateful, man.
Yes. Item number 3.
आगे कोई बोलता नहीं है। Please, Lordship, I'm appearing for the petitioner in serial number 3 and 4.
Who is Mr. Anjir Ali? You have been entrusted with the job to defend the private respondent most probably.
My apologies for this, what appeared on the last day.
Yes.
Today, I will appearing on behalf of the respondent number 1. In the matter of item number 4.
Yes.
And item number 3, my senior counsel.
My lord, I have received the engagement letter. I prayed for time for prepare the.
Prepare code hard. What is hard? New matter, do it.
Recently, I have received the engagement letter. Recently, I have received the engagement letter from
Your
SLSA.
client himself.
SLSA.
Oh, SLSA.
Yes.
But where is your client?
Now
We have appointed.
still I did not contact with my client because letter was recently given. Just I try to search my client only. A time may be given or next circuit I contact with the client and prepare to hearing this matter.
Next circuit, not in this circuit, it would not.
No,
Next week maybe. Next
well,
week.
let it be kept on Monday, Lordship. He cannot be contacting that client because he's appointed by the legal services aid. My lord, nobody is going to be able to be in contact. So, my lordship, he can only argue on law points even otherwise because he is not aware about the facts or anything of this case. Because
Let him make an effort.
my lord, let it be decided in this circuit, Lordship. This petition is pending since long, Lordship.
I have understood.
Next, next week, my lord.
Hmm?
6 or 7, any date may be fixed. Next week.
6 or 7,
Yes.
5th, no, 6.
Fifth, I will not. If I,
6th,
6th,
6.
6th.
yeah.
I'm grateful. My lordship, if the other council is ready, he can make his submissions. Mr. Amjad Ali.
Yes, your lordship. First of all, the matter is, the writ petition filed by the petitioner, it is maintainable or not, that question will first come. For according to the law, the writ petition filed by the petitioner is not maintainable.
Why?
Section 227 is not, it's not maintainable. The reason is that the revision order has to be challenged on revision, not in the writ. And apart from that, the lower court. order,
Now, where it is written that the rate is not maintainable?
it is there. Section 227. In some exceptional case, only the court can allow.
That is another aspect of the matter. He has filed the.
The writ,
I pointed out this matter before our officer today as well as to the year, how it has been registered as WPA. It should have been registered as CRR. Okay, maybe under section it is 227.
227.
It is filed under section 220, under article 227. Generally, we follow, yes, 227.
227 much. It's not.
Read it 482. Most probably 482, now 528. So nomenclature has been the number which is allotted. We generally actually can it be changed now? Huh? You know, it should have been recorded as CRR. Huh? To the confusion. It is. So I can direct my register to change it as a CRR.
Apart from that,
If you all feel. Generally, we follow that writ petition which is filed under Article 226 in our jurisdiction, almost in all jurisdiction, it is registered as WPA or WP. Whereas if any order of the learned criminal code below is challenged under Article 227, that is registered as CRR. CRR, yes. If you want, I can direct my register to change it. What exact order?
that lordship, the order passed by the lower court, in some extent, it is bad in law.
That is merit. Are you arguing on merit today? Because same matter will be heard on 6.
My lord, both the councils are different.
I am ready to argue. The lordship is this.
Do it on 6. Okay, do it on 6. Similar matter will be passed. Upon hearing of the learned advocate appearing for the respective parties. During hearing, Mr. Ali pointed out that though this petition has been filed under Article 227 of the Constitution of India throwing a challenge to the challenging the order dated, assist us. I am to find it out.
I'm sorry, lordship, 1 minute.
Challenging the order.
I-
27/8/2024.
Not one order.
Challenging the order dated 27th August 2024. It is correct?
Yes, lordship.
We are challenging the order dated 27th August 2024 passed by the learned session judge in criminal revision number 08 of 2023. That means that you have challenged also the order of the magistrate also,
Yes, that is 18 April 2023.
as well as the order dated 18 February
18 April.
2023.
18th April 2023, passed by the London Magistrate in CR case number 6C of 2018. CR case number 63 of 2018. Challenging. As per the rules followed by this court, this petition should have been registered as CRR. But however, it has been registered as WPA. WPA registered as, it has been registered as. আপনি এক কাজ করুন। I am
Followed by this court, this petition should have been
registered as CRR. ঠিক আছে? But stop. Instead, it has been it has been registered as WPA 614 of 2024. আর পরেরটাও সেম অর্ডার লিখে ওই WPA আর একটা যেটা আছে another একটা আছে না, সেম লিখবেন, এটা শুধু নাম্বারটা চেঞ্জ করবেন। আচ্ছা, so to eradicate any possibility, so to eradicate any confusion regarding the regarding the petition being registered as WPA, we direct the register to register this petition as CRR such and such. Yes, okay. Renumber the same and place before this court.
My appearance should be recorded. I am from SLSA.
তাহলে ওপরে লিখে দেবেন যে মিস্টার
Allocation.
Sarkar has entered appearance being appointed by State Legal Services Authority on to defend the
Respondent number 1.
respondent number 1.
Mrs. Hina Ramesh Kumar Khatiria.
Has entered appearance being appointed by the State Legal Services Authority to defend the respondent number 1. ঠিক আছে? Respondent number 1 of both the petitions. Respondent number 1 of both the petitions. ঠিক আছে? Mr. Sarkar pays for a brief accommodation to obtain necessary instruction in this matter. ঠিক আছে? হ্যাঁ। আচ্ছা, leaves the matter for further consideration on 6th. ঠিক আছে?
Yes.
6. Leaves the matter for further
I'm
consideration.
grateful. I'm grateful.
Yeah. Next. Students, yes.
Lordship, I am for the petitioner, Lordship.
5 and 7 are common matters. Mr. Prashant appears for the respondent. Bill for short passover.
Your passport, not today. Do it tomorrow. Okay. Do it tomorrow. Get prepared and tomorrow. Okay.
Yes, sir.
Tomorrow.
Obliged, Lordship.
Item কত? Item number 8. না 8 পর্যন্ত বলে। ও 8 কি?
My lord, my senior attended for the petitioner. I prayed for let's matter fixed on next week.
I for this state, Lordship.
Next week. Okay, not this week. Yes.
My senior is attending for the petition. I prayed for let's matter fixed on next week.
Next week.
My lord.
For the
But do
respondent
it on next week, in the coming week.
Item 10, CR of 2025 with rank 1 of 2025.
Sir, namaskar.
হ্যাঁ, ইয়েস।
আমি স্যার অমিত বিশ্বাস স্যার আমার নাম
আপনার নাম কি?
অমিত বিশ্বাস।
হ্যাঁ, কি হয়েছে?
স্যার আমি ক্যাম্বেল বেগে থাকি স্যার।
হ্যাঁ,
ক্যাম্বেল বেগে থাকি, আমি ক্যাম্বেল বেগে যোগীন্দ্রনগরে থাকি স্যার।
হুম,
তো ওইখানে স্যার ডকুমেন্ট ভেরিফাই করার জন্য স্যার পুলিশ ইন্সপেক্টর আদিত্য নারায়ণ আর মনোহরন আর গৌরব ব্যানার্জি স্যার আমাদের থানায় নিয়ে যায় ভেরিফাইয়ের জন্য ডকুমেন্টস নিয়ে যায়, দেখায় না আমার রাত ভরে পিট হয়েছে স্যার। 8টার থেকে শুরু করে স্যার রাত 2টো পুরো মানে কাপড়া খুলে দেয়। ফের আমার মেডিকেল টেডিকেল কিছু করায় নাই। তারপরে আমি মানে কোর্টে ওইখানের কোর্টে কেস করছিলাম স্যার, মানে এগেনস্টে কমপ্লেন করছিলাম স্যার, তা কিছু হয় নাই স্যার। এই জন্য স্যার আমি হাইকোর্টে এসেছি স্যার।
হাইকোর্টে আপনি কি করেছিলেন?
সারা ডকুমেন্ট সাবমিট করেছি স্যার।
ইয়েস, কর্মকার।
Copy of interest. That's up. I cannot say submit anything because I have no record at all.
But affidavit of service has been filed. You are appearing for the state.
For the state, but I have.
আপনার কাছে কপি আছে?
জি স্যার।
কপি একটা দিয়ে দিন ওনাকে। আর আপনি পারবেন
জি স্যার
নাকি আপনি ওই জন্যই বলা হচ্ছে সরকারের তরফ থেকে ব্যবস্থা আছে, আপনি যদি মনে করেন আপনি লিগ্যাল এড সার্ভিস থেকে আপনি উকিল পাবেন, আপনি কি সেই উকিল নেবেন?
হ্যাঁ স্যার করে দেন।
হ্যাঁ,
হ্যাঁ করে দেন।
কারণ এখানে অনেক সব আইনের ব্যাপার হবে তো,
হ্যাঁ, হ্যাঁ।
অত তো আপনি পারবেন না, উকিল দাঁড় করালে মনে হয় ভালো হবে।
ঠিক আছে।
হ্যাঁ, এবার সিদ্ধান্ত আপনার। আমি আপনাকে শুধু ইনফরমেশন দিলাম যে দেশের আইন অনুযায়ী আপনি উকিল পেতে হকদার। কি করবেন?
স্যার
আপনি নিজে করবেন না উকিল বাবু দেবেন?
না স্যার আমি উকিল করে দেন।
এই এখানে কি আছে, কি আছে? অলোকেশ বাবু তো দেখছি করছে, আর কি আছে? হু এলস? আচ্ছা, ডিউরিং হিয়ারিং আছে। কপি সার্ভ করেছেন?
হ্যাঁ স্যার।
একটা করে কপি উনি পাবার হকদার, ওনাকে দিন। আপনি এখানে যা ফাইল করেছেন তার সমস্ত একটা কপি করে ওনাকে দিতে হবে।
হ্যাঁ স্যার দিব। স্যার দিয়ে দেবো, এখন তো আমার কাছে একই কপি আছে না।
একটা সব এই আপনার দুটো এখানে পিটিশন আছে,
হ্যাঁ
সেই দুটো কপি ওনাকে দিতে হবে।
হ্যাঁ স্যার দিন।
আচ্ছা, করুন যে মিস্টার কর্মকার entered appearance on behalf of the respondent. ঠিক আছে, আচ্ছা। The petitioners undertake to serve the copies of the this revision petition as well as the this revision, this petition of revision, petition of revision as well as the copy of, the application for condonation of delay, ঠিক আছে, to Mr. কর্মকার। কবে দেবেন? আজকে দিতে পারবেন?
হ্যাঁ স্যার।
হ্যাঁ, আচ্ছা, উইদিন 31st আমি কালকের মধ্যে দিয়ে রাখলাম, কিন্তু আপনি আজকে দিয়ে চলে যান। আচ্ছা, স্টপ। আচ্ছা, the petitioner appearing in person place that a learned advocate may be engaged to represent him before this court from legal aid service authority. ঠিক আছে? ঠিক আছে, in views of such submission made on behalf of the petitioner, the registrar is directed to make arrangements so that an advocate from the legal aid services is arrangement so that an advocate from legal services authority is provided to the petitioner who will represent the petitioner is provided to the petitioner. ঠিক আছে আচ্ছা Release this matter for further consideration in next circuit bench, subject to his convenience. Okay, তাহলে পরের সার্কিট বেঞ্চে এটা হবে, পরের সার্কিট বেঞ্চ 17 তারিখ থেকে ওর মধ্যে হবে, ঠিক আছে? জানবার দিলে না কপিটা ওনাকে জেরক্স করে দিয়ে বের চলে এই ask him to বুঝতে পেরে গেছে। Yes, IP number 11.
This is a matter where the petitioner faced a trial in regard to a case of 2007. Allegations were 468, 471, 409. In the initial trial, he was convicted after a gap of 17 years in September 2024 by the learned CJM Mayabandhu. That went in appeal. The appellate judgment has now come on 31st December 2024, confirming the trial court's order and further directing him to surrender within 1 month to serve out his sentence. Now here we have come up in revision because there are 4 issues which have not been considered by the learned court below. The first of them, which is the most basic, let me start with that because that is enough for this matter to be admitted. Kindly comes to page 136. Now, this is a case where a total of 21 witnesses were examined, including formal witnesses, prosecution witnesses, police witnesses, and all. Kindly see 136. This is the 313 examination. Did you hear the evidence given? Yes. I shall ask some questions. Yes. Prosecution witnesses depose before this court that you have manufactured and fabricated false document in the name of others, among whom some were dead at that point of time. By fabricating documents, you have misappropriated government money in digging a pond in the name of those innocent persons. What is your say? It is wrong. Do you want to say anything? One question. This is a complete violation of law. My lord knows, so far as 313 is concerned, it is strike law that all the circumstances have to be put specifically. You cannot ask a general question without putting the individual circumstances that have come out from each of the prosecution witnesses. This is an error in law. This is the first and basic point. And on this point alone, it is enough for me to say that there is a ground for this court to admit this criminal revision. This is the first one. The second point, now this is one end of the trial, 313. Kindly see the other end of the trial, which is that the charge, page 56. This is really an interesting legal question.
Yes.
Page 56, 2 heads of charge are against Rama Rao and Shushanto Bishar. Rama Rao, the petitioner, he was a surveyor of the department who was in charge of maintaining the muster roll. Actually, one pond had to be dug. The pond was dug, admittedly. And for that, labor had to be taken from the local place because this is in North Andaman somewhere. All these people, the officers, had gone from Port Blair. So this man also, admittedly, he's an agricultural surveyor who is not of that local area. So in order to get the local labor, the Pradhan is supposed to identify who are the people who will work. So the Pradhan brings the list of people that they will come and work. They do the work, pond has been dug. Now when the money has to be disbursed, this whole case involves a princely amount of rupees 25,000 only. Now when that money has to be disbursed, again the Pradhan has to identify those people. My job, I have the khata. They will take the money and they will sign in the khata. This is the case. Now, what has happened is one person who had worked, he died while the work was going on. He was supposed to get 3,000 rupees. Now that person, his son came and asked for the money. We said that, look, we cannot give it to you. This money will go back in the government khata. Then you can claim it separately from whoever it is, but we cannot give it to you directly. Now the son has gone and filed a complaint saying you are giving everyone like this. X has worked, but Y got the money. Z has worked, A got the money. Now in the village, this is what was going on, that some people are working, some people are getting the money, but it was not a situation that I have stolen the money. The situation is that who has worked, someone else has come and claimed on his behalf. So on that basis, that boy has gone and filed a complaint saying my father passed away. They are not giving me his money. Instead, they are giving other people money. This is the whole case. Now, when the Pradhan and I are both made accused in the case. Why? Because the Pradhan has brought the people and identified the people, and Khata was maintained by me. My defense was very simple. I don't know anyone. If the Pradhan brings and tells me that this is XYZ, one of the arguments is Aadhaar and all was not verified. My lord knows in 2006-7 there was no such Aadhaar. That came only maybe in 2010-11. Now the point is this: my job is to pay out the money to the person identified to me by the Pradhan. I have done so. All the officers who have been examined by the prosecution, they are saying the same thing. Junior engineer, the superior officers of the department, they are saying that our team went there to do the pond work. Whoever was identified, he has given the money. What is wrong? This is the case so far as this man is concerned. Now kindly see the chart. Now the first head of charge, so far as I and Shushanto. Shushanto is the Pradhan. By the way, my lord, I must say this. Shushanto passed away during the trial. So far as he is concerned, case was filed for him. That you during Jan-Feb 2007 at Profullo Nagar under jurisdiction of PS Biriground in furtherance of your common intention, forged a certain document, to wit, acquittance roll for the month of Atto during the payment towards the payment of wages in connection with the construction of MI pond in the field of Sri Jagannath Shikdar, intending that the same shall be used for cheating and thereby committed an offence under 468. Now I am asking myself, what is the definition of forgery? Suppose I am an authority who is authorized to write something down. What is a forgery? A forgery has to be as per the definition that is there in the old IPC, that the document itself is a false document. Now here, I was just discussing this example with my learned friend. Today, suppose I am the person who has to issue a driving license to someone. Now that person, he is 16 years old. He comes and pays.
Offense lies in identification, not in forgery of documents.
So the question,
Yes.
it's not a forgery because I am authorized to make a document. If I have forged someone else's signature, I could have understood. Now, who has come and signed the khata? It is not my signature. Someone else has come and signed it. So the question of forgery, there's a legal point whether the ingredients of the offense could at all have been framed like this, in this manner of charge, and whether the offense lies. The second issue here is, now they say 471, which is the second head of charge, that I use this for the payment of wages. But that is the whole point. It's my job to use that as for the payment of wages. Now, if the person who is coming and signing is not the person who has worked, who has committed the offense? It is that person, or the person who is identifying him. So here, whether these charges could at all have been framed in this manner, there is a doubt. Point number 3. If my lord sees the evidence for a moment, first of all, let us look at PW2, page 70. Page 70, PW2.
6. Yes.
So this page 70, PW2, C. Binod Kumar, he was the superior officer. I am now posted at Campbell Bay as agricultural officer soil. I was posted as soil conservation assistant at Mayavandar in the year 2007. We utilized Rajiv Gandhi Rehabilitation Program Fund for excavation of MI pond and construction of RCC ring well. One of the beneficiaries of that fund was Jagannath Shikdar. Assistant Director Soil Conservation was a controlling in charge of utilization of this fund. To facilitate this program, our directorate engaged graduate engineer to ensure implementation of the program. Surveyor M. Rama Rao was given the responsibility to maintain the attendance register master roll in respect of this program for their panchayat, namely Horinagar, Bashantipur and Swadesh Nagar. One construction of MI pond was made. So it is no one's case that there was no work done. Work was done. was made at the land of Jagannath Siddhar, resident of Bashantipur Panchayat, Prafullanagar village through the fund. M. Ramarao was also assigned to supervise the work and take measurement and for making payment for the same work in regard of said three panchayats. M. Ramarao prepared the attendance sheet and acquittance roll for payments to laborers of this work. About rupees 1,62,000 and atho was spent from the fund for the construction of the pond. I collected the said fund of rupees 162,060 from Assistant Director, handed over to Ramarao, who was directed to make payment in consultation with PRI members. Pradhan of Bashantipur Panchayat was Sushanto Biswas. Pradhan used to identify the workers who were engaged to do this job to collect and receive payment in regard of their work. Pradhan used to sign in the acquittance roll. About rupees 3,770 was not paid to one worker, namely Dhiren Mistry. Dhiren Mistry is the dead person, the father of the company. Out of that fund, in regard of his work, as he expired prior to receive his wages, this money was then deposited in government account by Chalan. Police SHO Biligram seized attendance register, field register, acquittance roll, office order constituting monitoring committee, office order in regard of deputing staff, associated bank documents. I signed in the Caesar memo. This is my Caesar, seized documents. These are the seized office order. Then he has identified. The next page, cross. I was posted at Mayabandar since the year 2004. This RGRP was launched in the year 2005-6. M. Ramarao was assigned to look after the respective job of this program on the strength of office order. Graduate level engineer was assisting M. Ramarao in this job. I also used to supervise the job with the concurrence of Panchayat Pradhan, PRI representative. No payment could have been made to the laborers. Ramarao, myself and government engineer were not local public of that area. Ramarao was authorized to maintain muster roll, attendance record in regard of the work at the said three panchayats. Then the next page, kindly see the most important line.
Yes.
Page 74. Pradhan and PRI furnished the list of workers who could be engaged to perform the said work. The job was completed.
What is PRI?
Panchayati Raj Institution.
Oh.
PRI means Panchayat members.
Okay.
Gram Panchayat, Gram Sabha, whatever. So they formulated the list. They have given the names of the workers. And on the earlier page, we have seen they have identified the workers that who has worked, who has to be paid. This is the prosecution star witness. Thereafter, the job was completed as per specification. Cross-examination for Sushanto, official records and documents of acquittance roll was prepared by the office staff. No outsider put any endorsement therein. Volunteers, party concerned signed therein after receiving the payment, and Pradhan signed thereon in blue ink as witness to the fact of making payment to the parties concerned. Some endorsement therein was made in black ink. It is a fact that these endorsements were not made by the Pradhan. I did not visit at the spot. I thought during construction, I visited occasionally to supervise the progress of construction. I saw PRI members at the spot of construction when I went there. Whenever I went at the spot, no villagers or laborers made any complaint to me regarding payment and construction. I have no personal knowledge. So the question here is, what is the actual offense? I am the supervisory person who maintains the register. The list is given by Pradhan and Panchayat members. They identify the people. Those people come, they work, they take their money, they go. What is the expectation of me that I will check each one's ID card with the face, with the thumbprint, with what? That is not clear. Now, that is actually what this whole case is about. That complainant says, my father died, you didn't give me the money, you are giving other people money. This is the case. Now, after PW2, PW3, he is the supervisor of PW2. GB
So, according to you, no offense has been committed.
Has been made out. Committed is definitely there, but on the face of it, on the prosecution evidence, cannot be said that an offense exists. The fourth point is so far as the exhibits are concerned. 41 documents were exhibited, which is why I said the LCR is so required. In each of those documents, unfortunately, I don't have the entire bundle. In the exhibits, it is very clearly shown which is the signature, which is the Pradhan's counter signature, who has identified, who is the person. It is clearly in the exhibits, which is why the only thing that they can try to make out a case against me is that that book, the register, was undermined. So we need to see the exhibits, and if my lord goes through the evidence, PW 2, 3, 7, I think these are the three main witnesses. The point is this: A, a charge could not have been framed. B, the 313 is totally illegal. C, on the points of law arising out of appreciation of evidence, a conviction could not have been sustained. On these points, today I am only praying that the revision be admitted, the LCR be called for, and since this man has been enjoying bail since 2007, he has never abused, never absconded, let him continue on such bail till such time as the matter is mature for hearing. This order which has been passed, so far as the direction is concerned, the second last page of my application,
Yes.
the convict
Directed to surrender.
directed to surrender within 1 month. Now, this order was passed on 31st of December. Today we are on 30th of January. Today is the last day. If today this order is not stayed, then warrant would be issued. And if I am able to make out a prima facie case before this court that there must be reconsideration of this on these grounds, then this man will be prejudiced if he has to go and sit in custody until the time that the matter could be heard. So this is my very humble prayer as of today.
Yes, Mr. Kormakar.
Lordship, I just. Yeah, Lordship, conviction was given under section 471 and 409 IPC also. That regarding forged document. Even though Lordship.
468,
471,
471,
409.
468, 471.
So that used up genuine, even though Lordship, at a first motion stage, Lordship, at this stage, LCR may be called for, Lordship. Thereafter, on merit can be heard.
Mr. Kobi, learned advocate, repenting the petition, drawing my attention to the answer and the to the questions put to the accused person during his examination under section 313 of Code of Criminal Procedure in bracket in short the code. Argues that as per the settled proposition of law, an accused person should be asked of the law, the accused under section 313 of the code, an accused person should be put all the questions regarding the circumstances should be asked or should be confronted, should be asked all the questions, should be asked all the questions regarding, should be asked ask the questions regarding all the facts and circumstances which come before the court during examination of witnesses. Court during examination of witnesses. আমি যদি প্রতিটা ওয়ার্ড মিস করেন তাহলে আমি শুনুন, আমি প্রতিটা বই আর এইটা হ্যাবিট আমি ওই দ্বিতীয়বার জিজ্ঞেস করে শোনা, আমি শুনো ওইটাও টাটারি নেই ওয়ার্ড, আমি শুনলেই কানটা যাবে, ঠিক আছে? Witnesses, stop. We submit that in the present case only one question has been examined to the accused person. In his view that examination of accused person has not properly done under section 313. Stop. Acha. Drawing my attention to the deposition of PW2, he argues that it was the duty of the Pradhan concerned to engage the labor and the amount and the wages were paid to the persons identified by the Pradhan. He submit that the petitioner, being a government official, cannot have any, did not have any role in identification of the labor who was engaged by the Pradhan concerned. He submits that in evidence also as such fact has come out, and the evidence brought on record was not sufficient to hold conviction in the given case. Sufficient was not sufficient to hold the conviction against the present accused person. He further submits that there 41 documents have been exhibited, and 41 document has been exhibited, and
those exhibits are lying with the lower court record, which needs to be perused to ascertain whether at all there is an offense of forgery.
and those documents is required to be brought on record and examined.
44, man, not
44. Record and examined by this court to ascertain whether the offense alleged in the affair was at all committed or not. He submit that has at all been committed or not. At all been committed or not. He submits that the money which was due to the deceased father of the complainant is still lying in the is still lying with the respondent
with the government account.
Still lying in the government account. So in that sense, no offense has at all been committed. So no offense has at all been committed, and none has acquired any wrongful gain, and in exchange of wrongful loss of any person. He submits that here, while disposing of the appeal by the learned session judge,
Additional sessions.
or additional session judge, North and Middle Andaman Maya Bandar, has directed the petitioner to surrender before the trial court within 1 month from the date of that order. And he submit that the said period is expiring today. He submits that said period is expiring today. The said period is expiring today, unless and until the said order is stayed. The petitioner will be seriously prejudiced, and this petition will be infructuous. Stop. Yeah, Mr. Kormokar, learned advocate, entered appearance on behalf of the respondents. He submits that if the lower court records is called for, then it would be evident that prosecution has successfully proved its case before the learned trial court. Yes, Mr. Kormokar?
Lordship. And also
That
submitted
the
that
prosecution had successfully proved its case before the learned trial court.
and convicted under section 409 as well as 471. If that my submission. Even though 468 not attracted.
Convicted under section for the offense punishable, for the offenses punishable under section 409/468/471 IPC. Stop. Had the learned advocate peruse the materials on report. ঠিক আছে? আচ্ছা, হ্যাঁ। Scope of revision is limited and it can be entertained if there is some procedural irregularity. Some procedural irregularity, or if the decision, maybe it concurrent finding of the course is perverse or based on no evidence. Evidence, stop. Acha. Consider having heard the learned advocate representing the party and considering material of the record, including the materials on record and including the questions and answer. Questions put to the accused person during examination of 313 of the code, as pointed out by Mr. Kobi. And other documents, I am of the view that prima facie, a good arguable case has been made out in this instant division. That a prima facie good arguable case has been made out in this division. And accordingly, the same is admitted, stopped, and say if the order passed or by the learned additional session judge directed the convict to the petitioner to surrender before the trial court is not paid. Stayed, the petitioner will suffer irreversible injury and the petition of revision would be infructuous. In view thereof, the order whereby the portion of the order whereby the
Order dated 31st December.
portion of the order dated is such and such dated
31/12/2024.
31/12/2024, whereby the petitioner was directed to surrender before the trial court is stayed. Stayed till the disposal of this petition stopped. Acha.
Whoever the petition was directed to.
Stayed is stayed till the disposal of the revision application. Is till the disposal. Till the disposal of the revisional application. Stop. Acha. Let the LCR be called for. Acha. List the matter for. But whether I am thinking whether the order of sentence passed by the learned court below is required to be stayed or not.
If this order is stayed, then effectively, I think
It would be.
it covers.
Okay, order by portion of the order. Okay. দেখে নেবো এটা কি বলেছিল, কি সাজেশন দিয়েছিল। What was the conviction?
My lord, the 409, 3 years, 467, 2 years, 471, 2 years. In fact, here technically, my lord is correct, because even if this order is stayed, that order remains alive. So whether it would be necessary, your lordship can say that.
So order of sentence passed by the learned trial court in such and such paragraph লিখুন, আমি pen drive এ দেবেন। Order of sentence passed by the learned trial court is also stayed.
Order dated 30.
Passed by the respondent হবে passed by the learned trial court
Learned Chief Judicial Magistrate, North and Middle Andaman, Mayabandar.
বলছে। লিখুন
The order of the sentence passed by the learned
trial court passed by the learned chief judicial magistrate.
North and Middle Andaman at Mayabandar.
North and Middle Andaman Mayabandar
Dated
in একটা কিছু আসবে GR
in
case
GR case 878 of 2007.
is also state.
Order dated 30th September 2024.
30th September 2024 টা লিখে রেখে order dated 30th September 2024 order dated এইটা লিখে রেখে আমি ওটা পেন দেব।
Three other prayers. One is that my lord, urgent plain copy or urgent server copy or
আচ্ছা
something.
urgent plain copy. Urgent. Let a plain copy of this order be supplied to the petitioner on urgent basis.
And second pair is liberty to communicate, because then by today, if we can immediately inform, then on the lawyer's communication letter, at least we can inform the learned court below that the order has been passed, because, my lord, it
Acha,
will
liberty
take
is
some
given to
time.
the learned advocate to communicate this order along with the copy of the, along with the server copy of this order. Advocate to communicate this order to the learned trial court along with the server copy of this order.
And third prayer is that usually what we do is, because Mayabandhar registry also communicates by abundant caution. So registry communicates to the learned court below directly also.
Okay, registry is also directed to communicate this order to the concerned trial court.
Deep relation.
Yeah.
Very great.
ইয়ে করুন তো, আপনি পেন ড্রাইভে দিয়ে আনেন। Yes, next civil division, yes.
The opposite party.
Not today, Your Lordship.
My lord, yesterday my learned friend.
That matter.
second appeal, prayed for next circuit. I prayed for next week. So matter was urgent to next circuit. I am in this matter, I am praying for next circuit.
Next circuit.
Yes.
Only not today, Your Lordship. Just not today, Your Lordship. Tomorrow it will be done positively.
In this matter, he is in a advantageous position. He is enjoying something. Are you in possession?
No interim order.
No, are you in possession,
No.
partisan suit, etc., nothing, anything like that.
Only not today, Your Lordship.
So pendency of this petition will benefit you.
No, it will not benefit. Except material instruction,
Not
nothing.
today, Your Lordship. My
So what can you do accordingly? What can be done? Monday. Okay, Monday.
Holidays.
Yes, Monday, next.
Holidays, holidays.
Oh, yeah, that is fifth. Fifth. What are you doing? Yes, yes.
There is an extreme urgency in the matter. This has to be taken up.
Your Lordship, I pray for Passover in this matter. Only a short.
Passover will
So it will
be.
take us to tomorrow only.
Then not today, but my senior is ready for hearing, Your Lordship. She is appearing on behalf of the respondent, Your Lordship.
No,
For-
for not all respondents. I appear for one of the respondents.
For
So
respondent,
do it tomorrow,
for his fine, Your Lordship.
but do it since he has some urgency. Hmm.
Item 14, WPA 428 of 2024.
Lordship, I am appearing for the respondent authority, Lordship.
Yes,
Senior is on behalf of the petitioner, Your Lordship. I pray for not today, Your Lordship.
not today. You are for the respondents.
Lordship,
Respondents.
let it be on 5th, Lordship, because I am suffering from throat infection, Lordship. So it will be difficult for me to come tomorrow.
Fifth,
Oblige.
15.
Item 15, WPA 43 of 2025.
15th, Lordship, generally I used to appear on behalf of the respondent authority, but no copy has been served, either to the department nor to me.
Lordship, in this matter, copy has been served to department.
He is saying copy has been served to department. Yes, yes. Other copy.
Let me take instruction and come back on 5th, Lordship.
Fifth. Okay,
Fifth.
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 Okay, fifth, come on, fifth.
Obliged, Lordship.
Item 15, WPA 25 of 2024 with Connect of 2022.
Content.
Petitioner Miller.
For the opposite party.
This
is not the contempt application fixed for consideration. It's an interlocutory application registered at Can month of 2024. Seeking a proceeding under section 347, this is perjury. Is pending for consideration. Contempt disposed of.
There was a direction for filing a reply.
Just 2-3 days be given on Monday or on Wednesday or Thursday, it can be. I'll use when.
So I am just simply adjourning.
Simply
it.
adjourning.
I am not passing any order.
For this
Simply.
For this
6.
16.
No, on 6 it should be.
Fifth this May.
Fifth. Okay, fifth.
Obliged.
Yes.
Item 17, WPA 6 of 2024.
Last matter of this day. Again, you will pray for adjournment.
Next circuit, Your Lordship.
At their request, but maybe.
On the based on the prayer made on behalf of the petitioner, leaves the matter based on the pair, BASED, based on the pair made on behalf of the petitioner, comma, list the matter and in the next circuit bench, comma, subject to its convenience.
Their appearance may be recorded.
Appearance,
Appearance record.
নামগুলো দিয়ে।
Deeply.
That's all.